Today, we're digging into the official documents of a classic David and Goliath story. It's about one homeowner, her powerful homeowners association, and a fight over a very basic right. Let's get into what happens when just one person decides to demand accountability.
It's a question a lot of people find themselves asking, right? But what we're looking at today isn't some hypothetical. This is the real story of one resident who decided she was going to find the answer and what went down when she put the entire system to the test.
So here's how we're going to break it all down. We're going to follow the official record through 5 parts. We'll start with the initial complaint, then look at the years of total inaction, then the big showdown at the hearing, and finally, the legally binding verdict.
Okay, so our story starts with a woman named Nancy Babington. She's a resident in the Park Scottsdale 2 townhouse community. And, like most homeowners, she just expected her HOA to play by the rules. But she started to notice a pretty serious problem.
And this wasn't just some casual gripe she posted online. No, she filed an official, legally recognized petition with the state of Arizona. In it, she alleged that for years, her HOA's board of directors had been just straight up violating the law. So as the case started moving forward, the real scale of this problem became, well, kind of shocking. This wasn't a one-time thing, like they forgot one year. This was a pattern. And the crazy part, the HOA didn't even try to deny it.
In their own official response to her petition, the HOA just laid it all out. They admitted it. For 4 years straight, 2010, 2011, 2012, and 2013, the board just didn't hold a single annual meeting for the homeowners.
4. Think about that. For 4 consecutive years, the most basic, fundamental event of community government just didn't happen. That's 4 years with no public forum, no elections, and no homeowner vote on community business. And the consequences? They were huge. Testimony from the hearing later revealed a complete breakdown of any kind of democratic process. Of course, without annual meetings, there were no elections, so board members just stayed on long after their terms had expired. Some of them, according to testimony, had never even been elected by the homeowners at all. Instead, everything was done behind closed doors in these so-called executive sessions.
So this all led to a formal administrative hearing. This was the moment of truth, where Miss Babington and the HOA board would finally have to answer for everything in front of a judge. The arguments laid out in the official record are just so stark. Ms. Babington's case was simple. Hey, this board is illegitimate. They're operating without any mandate from us homeowners. And the HOA's response? Well, they admitted it, but they tried to say, well, we attempted one in 2014, but not enough people showed up. But then came the most stunning moment of the entire hearing. Okay, get ready for this because this is a direct quote from the testimony of a board member, Joe Silberschlag. He got up there and said that the lack of meetings wasn't an accident. He explained that because of the HOA's poor financial situation, quote, we chose not have annual meetings. It was a deliberate choice. With an admission like that on the record, this was no longer a he said, she said situation. At this point, the judge just had to look at what was written down, first in the HOA's own rulebook, and then in the state law. And the HOA's own bylaws were crystal clear. Article 3, Section 1 says an annual meeting shall be held, and it even says why, to elect a board of directors. So the board had broken its own foundational rule. And this wasn't just some internal rule. Arizona state law itself is just as clear. It says a meeting shall be held at least once each year, and in legal terms, shall is not a suggestion, it's a command. So faced with the HOA's own admission, its own bylaws, and a very clear state law, the judge had a pretty straightforward path to a decision. The final order was swift and it was conclusive. The judge found that the Park Scottsdale 2 townhouse HOA had in fact violated the law. That was it. The homeowner was right. The failure to hold those meetings was now an official, adjudicated violation of Arizona statute. And the ruling absolutely had teeth. The judge issued 3 very specific orders. First, the HOA had to schedule an annual meeting within 60 days to give the homeowners their rights back. Second, they had to pay Miss Babington back her $550 filing fee. And third, they had to pay a $200 penalty to the state. And after a little time for review, the judge's decision was certified on April 18, 2014. That made it the final administrative decision. It was official, it was legally binding, and it was a huge victory for one homeowner who just demanded that her HOA follow its own rules. So this whole case, drawn right from the public record, really shows that all those governing documents and laws, they aren't just suggestions, they're enforceable rights. Which kind of leaves us with one last thing to think about. Who holds the power where you live, and are they being held accountable?